$165,140. That's what disappeared from my life in the 5 months I spent flat on my back on doctor-ordered bed rest, trying to keep my daughter alive inside me. I didn't find out about most of it until she was already 3 weeks old. I was healing from an emergency C-section, running on 2 hours of sleep at a time, and I opened our joint checking account on my phone to pay for a box of newborn diapers. The balance made me physically sick. Not low, not tight, nearly empty. An account that should have held close to $90,000, our house down payment fund, 5 years of careful saving, had $1,112 in it. My mother-in-law had been helping with our finances since week 20 of my pregnancy. That's the word she used, helping. She had power of attorney, she had access to our HSA card, she had the login to our insurance portal because I was too sick, too swollen, too exhausted to deal with explanation of benefit statements while I was trying not to lose my baby. By the time I was strong enough to actually read a bank statement again, she had opened a store credit card in my name, redirected thousands of dollars in insurance reimbursements into an account I'd never heard of, and funneled tens of thousands of dollars through a postpartum doula business that turned out to be a shell company she owned herself. She didn't just control my pregnancy, she used my pregnancy as the door into every account I had. She thought a woman flat on her back for 5 months, terrified for her baby's life, would never be sharp enough to notice and would never be strong enough to fight back once she did. She was wrong. Welcome back. If this is your first time here, this channel is about exactly this: greed, betrayal, and the deeply satisfying process of getting every single dollar back from the people who thought they'd never get caught. Today's story involves a forged power of attorney signature, a fraudulent shell LLC posing as a postpartum care business, a HELOC draw I never approved, and a mother-in-law who used my highest risk pregnancy, the most vulnerable 5 months of my entire life, as cover for financial exploitation. If you've ever had a family member who wanted just a little too much control, who framed control as care, who made "let me handle that for you" sound like generosity instead of what it actually was, stick around because you're going to want to see how this ends. I'm going to walk you through exactly how I built the case, exactly what the forensic accountant found, and exactly what it took to get a criminal conviction and every single dollar back with interest. Subscribe if you want more of these. Let's get into it.
My name's Jenna. I'm 33. My husband, Mark, and I got married in 2020, and after 3 years of trying, 2 miscarriages, and 1 very difficult round of fertility treatment, I got pregnant in early 2023 with our daughter, Rin. It was, from almost the beginning, a high-risk pregnancy. I had a condition called placenta previa, where the placenta partially covers the cervix, plus a history of preterm labor risk from the miscarriages. At my 20-week anatomy scan, my OB looked at the imaging, looked at me, and said the words that changed the entire shape of the next 5 months of my life. I want you on strict bed rest, starting today. Strict bed rest, for anyone who hasn't lived it, doesn't mean take it easy. It means lying down 22 to 23 hours a day. It means someone else does the grocery shopping, the cooking, the laundry, the mail. It means you cannot drive yourself to your own appointments. It means every single logistical thread of your life has to be picked up by somebody else for months while you lie there terrified that any wrong move might mean losing your baby. Mark worked full-time as a project manager and couldn't take 5 months off. We didn't have family nearby on my side. My parents live overseas. My mother has her own health issues that make travel hard. So when Mark's mother, Diane, offered to step in and run the household during my bed rest, it felt at the time like an answer to a prayer. Diane is 61. She spent almost 3 decades as a bookkeeper for a mid-sized construction company before retiring in 2019, which I want you to hold on to that detail because it matters enormously later. She is, by every outward measure, extremely competent with money, spreadsheets, and paperwork. That competence is exactly what made her offer to help feel like such a relief, and exactly what made her so good at what she eventually did.
In week 21, Diane moved into our guest room, just for a while. She started, reasonably enough, with groceries and meals, then laundry, then answering the door for packages. Within about 2 weeks, she'd naturally slid into managing our mail, including, crucially, our health insurance correspondence, which for a high-risk pregnancy is a genuinely overwhelming stack of explanation of benefit statements, pre-authorization letters, and billing notices. She is the one who first raised the idea of a power of attorney. If something happens with the baby and you need surgery fast, she said, sitting on the edge of my bed one afternoon, you want someone who can act immediately, sign consent forms, talk to the insurance company, handle the bills, without a court getting involved. I've seen it happen with a friend's daughter. It got ugly. It sounded, at the time, like exactly the kind of practical, loving thing a mother would think of. Mark agreed it made sense. I agreed it made sense. We were both exhausted, scared, and grateful someone competent was thinking 2 steps ahead for us. In week 23, we signed a durable power of attorney, a legal document that gives someone the authority to act on your behalf, financially, and in a separate healthcare directive.
Medically, naming Diane as our agent, we had it notarized at our bank. Everything about the process felt appropriately formal, careful, even reassuring. That was the moment everything after it became possible. Looking back now, from the other side of all of this, I can point to at least 5 moments in those following months that should have registered as warnings. At the time, flat on my back and terrified about my daughter's heartbeat at every appointment, I genuinely could not hold the bandwidth to notice them the way I should have. Red flag 1. Diane insisted on being the one to talk to my OB's billing office and the insurance company every single time. Even for routine matters, I was perfectly capable of handling from bed with a phone call. When I'd ask what an EOB said, she'd give me a summary. It's fine, don't worry about it, I'm handling it, rather than showing me the actual document. I trusted the summary because I trusted her. Red flag 2. She started discouraging me from talking to Mark about money so you don't stress him out while he's working so hard, which in hindsight is a strange thing for anyone to say about a married couple's own joint finances. She positioned herself, gently and gradually, as the buffer between me and every financial conversation in my own household. Red flag 3. Around week 26, Diane mentioned she'd connected with a wonderful postpartum doula service for after the birth, run by a woman she trusted completely, and that she'd already put down a deposit so we wouldn't lose the spot. I never met this doula. I never saw a contract. I just trusted that my mother-in-law, the former bookkeeper, wouldn't hand over money without doing it properly. Red flag 4, Diane restricted who came to visit me during bed rest, always with a caring-sounding reason. You need rest, not visitors. The doctor said minimal stress, but the pattern was that she was the one deciding every time who I saw and when. My own sister, at one point, mentioned she'd tried to visit and Diane had told her I was having a rough day on a day I later found out I'd felt completely fine. Red flag 5, the one I think about the most, Diane once mentioned, almost offhand, that she'd moved some of the savings into a higher yield account for you, so it's not just sitting there. I said something like, "Oh, okay, thanks," and went back to whatever I was doing. I never asked which account. I never asked to see it. I was 6 months pregnant, on bed rest, and my entire nervous system was oriented around one single question: is my baby okay? I did not have room left over to audit my mother-in-law. I want to give you one specific memory because it captures the dynamic better than any general description can. It was week 25, a Sunday afternoon. I was propped up on pillows doing the thing you do endlessly on bed rest, which is essentially waiting. Waiting for the next appointment, the next kick, the next milestone that means the baby's a little safer. Mark had gone to pick up dinner. Diane came in with a folder of paperwork and sat on the edge of the bed, the way she often did when she wanted to talk through something, before Mark gets stressed about it.
She walked me through a stack of insurance denials, a pre-authorization for a specialist visit that had been rejected, a billing code dispute, the kind of dense administrative language that on a good day I could parse just fine, but on bed rest, drowning in fatigue and fear, felt like reading a foreign language. "I've got it," she kept saying, tapping each page. "I'll call them Monday. You just rest." I remember feeling an almost physical wave of relief every time she said that. Someone competent had this. I could just lie here and think about the baby. At one point in that same conversation, she mentioned, gently, that she thought it might also make sense for her to be added to our HSA card, since I'm the one driving to the pharmacy anyway, and that she'd already looked into it and it was a simple form, 5 minutes. I said sure. I didn't ask a single follow-up question. 2 weeks later, in that same guest room ritual, came the conversation about the power of attorney I mentioned earlier, presented with the same calm, competent, faintly urgent tone, the same folder, the same "I've already looked into this" framing that made every step feel like it had already been vetted by someone smarter and more capable than the version of me lying in that bed. Every single expansion of her access came wrapped in the same 3 ingredients: genuine-sounding concern for my health, a claim that she'd already done the legwork, and a subtle implication that questioning it would just create more stress for everyone at the exact moment I had the least capacity in my adult life to push back on anything. I didn't fight it because there was nothing on the surface to fight. Every individual request was reasonable. It was only the accumulation: HSA card, mail access, insurance portal login, power of attorney, authorized user status on checking, all inside about 8 weeks that, looked at as a whole, should have stopped me cold. Looked at one folder at a time on a Sunday afternoon, exhausted and scared for my daughter, it never did. By week 28, Diane had, functionally, complete operational control over our household finances. She had the HSA debit card for medical expenses. She had access to our joint checking account as an authorized user, a request she'd made for convenience, so I'm not constantly asking you to Venmo me for groceries. She had the notarized power of attorney, and she had 5 months of a genuinely exhausted, genuinely frightened pregnant woman who had every reason in the world to hand over the reins and not one spare ounce of energy to double-check how they were being used. We would later determine, through bank records, that the very first unauthorized transaction, a $1,200 transfer out of our savings account into an account we didn't recognize, happened in week 29, 6 days after Diane got authorized user access to our checking account. I had no idea. I was lying in bed tracking fetal kick counts. I gave birth to Ren on a Tuesday in late September, 6 weeks early, by emergency C-section after my blood pressure spiked dangerously, a complication called preeclampsia that can develop suddenly in high-risk pregnancies. She spent 9 days in the NICU. She's healthy now. I want to say that clearly up front because everything else in this story is secondary to the fact that my daughter is okay. But I came home from the hospital to a body that had been cut open, a newborn on a feeding schedule, and roughly 4 hours of sleep spread across any given night. Diane stayed on for the first few weeks to help with the baby, which, again, sounded generous. I did not have the capacity in that window to think about finances at all. It was mid-October. Ren was about 3 weeks old when I finally opened our banking app to pay for a delivery of diapers and formula and saw $1,112 sitting in an account that, as of the start of my bed rest 5 months earlier, had held just under $89,000. I remember staring at the screen and thinking there had to be a glitch. I called the bank. There was no glitch. I asked for a full transaction history, going back to May. What I saw over the following hour, scrolling through 5 months of transfers, withdrawals, and charges I had never made or authorized, was the first real crack in the story I'd been telling myself about my mother-in-law for the entire pregnancy. I want to walk you through what I found in that first pass because it only got worse from there, but this initial discovery alone was enough to make my hands shake. Multiple transfers ranging from $800 to $4,000 each, moving out of our savings account and into an account I didn't recognize, an account that it would later turn out belonged to Diane. Total across those transfers, roughly $31,000. A new store credit card, a major home goods retailer that I had never opened, showing a balance of $6,400, almost entirely charges for furniture and appliances delivered to Diane's own address, not ours. Recurring charges to something called Willow and Sage Postpartum Care LLC, the doula service Diane had mentioned putting a deposit on, totaling $14,800, paid directly out of our HSA. I had never met anyone from this business. No doula had ever come to our house, not once in the 3 weeks since Ren was born.
And the biggest number, the one that actually made me put the phone down and sit on the kitchen floor, a home equity line of credit, opened against our house in July for a limit of $50,000, with $38,000 already drawn against it. Mark and I had never applied for a HELOC. We had never been to the credit union it was opened through. Neither of us had signed anything, or so we thought. Total, in that first sitting, tracing what I could see just from our own account access, over $90,000. It would get considerably worse once we brought in a forensic accountant, but even that first number was enough to end the version of my life I'd been living for the past 5 months. Before I get further into the numbers, I want to name what doesn't show up on a forensic report. The specific kind of damage this does when it happens during the most physically and emotionally exposed period of your life. I had spent 5 months on bed rest, doing everything humanly possible to protect my daughter, and I came out of it to discover that the person I'd trusted to hold everything else together had instead been quietly dismantling it. There's a particular flavor of betrayal in that timing. It's not just, someone stole from me, it's, someone stole from me during the exact window I was least equipped to notice or stop them, and used my own fear for my baby's safety as the mechanism that kept me from looking too closely. Mark took it in a different but related way. Diane is his mother. He'd spent 34 years understanding her as protective, occasionally overbearing, but fundamentally someone who loved her family. Watching that understanding come apart in real time, transaction by transaction, while he was also trying to be present for a newborn in the NICU and a wife recovering from major surgery, put him in a state I can only describe as a kind of grief, with no clear place to put it. He wasn't mourning a death. He was mourning a version of his mother that, it turned out, might never have fully existed the way he thought it did.
We fought more than once in those first raw weeks about how to handle her, whether to give her a chance to make it right quietly, whether involving police and the DA's office was too far for a family member, whether Ren would someday resent us for the fact that her grandmother went to prison. We didn't have a script for any of this, and some of those conversations happened at 2 a.m. between feedings, both of us too exhausted to be fully rational, trying to figure out where the line was between protecting our family's finances and protecting whatever was left of Mark's relationship with his mother. In the end, the forensic numbers made the decision easier than the emotions ever could have. Once we saw the Shell LLC's formation date, 2 full months before my bed rest even began, it stopped being a question of forgiveness and started being a question of what a person who plans something like that in advance might do next if we let it go unanswered. I didn't scream. I didn't call Diane and accuse her on the spot. I called Mark, who left work immediately and came home white-faced, and together we did what I think most people would. We assumed there had to be an explanation, even a bad one, and we asked for it directly. We sat Diane down that same evening. Mark asked calmly about the HELOC. Diane's answer was that she'd started the process using the power of attorney, intending it as a safety net in case of a NICU emergency, and that she'd meant to tell us once things calmed down. She said the store credit card was for baby furniture we'd need anyway, and that she'd planned to transfer the items to us. She said the transfers into her own account were reimbursement for expenses she'd fronted during the 5 months she'd lived with us, though she couldn't, in that conversation, produce a single receipt. None of it added up, and worse, none of it matched. A safety net HELOC doesn't get $38,000 drawn down within 2 months of being opened. Reimbursement for expenses fronted doesn't total $31,000 from a woman who was living in our guest room rent-free. And the postpartum doula business? When I asked point blank for the doula's name and phone number so I could ask her myself why $15,000 in HSA funds had been billed for a service I'd never received, Diane got very quiet and said she'd have to look into some paperwork issues on their end. We asked her to move out. She left 3 days later, angry, insisting we were twisting a misunderstanding and that she'd always intended to make it right. Over the following weeks, as I started actually pulling documents instead of accepting summaries, the covering up became visible in retrospect, the way it always does once you know what you're looking for. The HELOC application, we discovered, had been submitted online through the credit union's portal using our home address, our social security numbers, which Diane had access to from helping with insurance paperwork, and we'd later learn from photographing our tax documents in case she needed them for the POA filing, and a signature on the closing disclosure that was clearly meant to be mine. It wasn't notarized in person the way our own POA had been. This credit union's remote online notarization process only required a video call, and Diane had conducted that video call, using an old profile photo of me pulled from Facebook as her verification image during a moment the notary's log showed lasted less than 90 seconds. The store credit card had been opened using a pre-approved mail offer addressed to me, activated online, with the account's paperless statements redirected to an email address that looked almost exactly like mine, different domain, that Diane had apparently set up months earlier and never mentioned. And Willow and Sage Postpartum Care LLC, when I finally looked it up properly in my state's business registry, was formed in March, 2 months before my bed rest even began, with Diane listed as the registered agent and sole member. Not a friend's business, not a referral. Her own shell company, created before my bed rest even started, sitting ready, waiting for exactly the kind of HSA-eligible expense category, postpartum doula care, that insurance and tax rules make relatively easy to bill for without triggering much scrutiny. That's when I found the smoking gun. Because a shell LLC formed 2 months before my bed rest even began isn't an opportunistic decision made under pressure. It's a plan. Somebody sat down months before I ever needed help with anything and built the infrastructure to bill me for care I would never actually receive. I want to be honest about what this investigation actually looked like day to day, because it wasn't glamorous. It was me nursing a 6-week-old at 3 a.m. with one hand and scrolling bank statements with the other. It was falling asleep mid-sentence on the phone with our credit union's fraud department. It was Mark taking a week of unpaid leave, which we absolutely could not afford, specifically to sit with me while we built a case against his own mother. Our first real move was revoking the power of attorney. Mark and I drove to the bank together, in person, and filed a formal revocation, which the bank was required to log and act on immediately, cutting off Diane's authorized user status on our accounts the same day. We also filed an identity theft report with the FTC through identitytheft.gov, which generates an official FTC identity theft report and a personalized recovery plan, a document that turned out to matter enormously later because it's the exact form banks and credit bureaus require to remove fraudulent accounts and dispute charges without treating you like you're the one under suspicion. We froze our credit with all 3 bureaus. We disputed the store credit card as fraudulent, submitting the FTC report as evidence, and after about 6 weeks of back and forth, the retailer's fraud department closed the account and zeroed the balance. That one, at least, resolved relatively cleanly, since it fell within clear federal identity theft protections. The HELOC and the Shell LLC were a different animal entirely, and that's where we needed a lawyer. We found an attorney named Carla Ibrahim who specialized in financial exploitation and elder and dependent adult abuse cases. And I want to pause on that specialty for a second, because it surprised me too. Carla explained that many states have statutes against financial exploitation of a vulnerable or dependent adult, and that some of those statutes explicitly include people who are, due to a medical condition, temporarily unable to manage their own affairs, which absolutely includes a patient on medically mandated strict bed rest for a high-risk pregnancy. It's not just an elder abuse statute, it's broader than most people realize, and it applied directly to what had happened to me. Carla's first move was demanding a full accounting from Diane under threat of a civil suit, which predictably went nowhere. Diane's attorney sent back a letter characterizing everything as informal family financial arrangements and miscommunication. That letter weirdly helped us, because it committed Diane in writing to a version of events we could directly contradict with documents. We brought in a forensic accountant, a meticulous woman named Preeti, who spent about 6 weeks tracing every dollar across our accounts, the HELOC, the HSA, and, once we subpoenaed records for it through the civil suit, Diane's own personal and business banking. Preeti's final report was worse than what we'd found ourselves, which I braced for, but which still landed hard. The HELOC draw, originally $38,000 in our initial discovery, had grown. Diane had continued drawing against it for weeks after we'd confronted her, before we managed to get it frozen through the credit union's fraud department. Final total drawn, $46,500. The transfers into Diane's personal account, which she'd characterized as reimbursement, totaled $34,200 by the time bed rest ended, not the $31,000 we'd first found, because 2 additional transfers had happened in the final week before Ren's birth, while I was in the hospital. The Willow and Sage HSA billing, once Preeti pulled the LLC's own bank records via subpoena, showed the business had no other clients, ever. Not one. It had been formed, funded, and used exclusively to extract HSA dollars from us. Total billed, $17,100, more than we'd first found because Diane had continued submitting claims for weeks after Ren's birth, backdating some invoices to services supposedly rendered while I was still pregnant. The store credit card, before it was closed, $6,400. And a category we hadn't found at all on our own. Preeti discovered Diane had also used the notarized POA, still valid until the moment we formally revoked it, to add herself as a joint owner on a small certificate of deposit, a low-risk savings instrument that Mark's late grandmother had left directly to him years earlier, worth $20,900, and withdrew the full balance 3 days after we asked her to move out, apparently anticipating exactly this kind of investigation and trying to grab what she could before doors closed. Total confirmed theft per Preeti's forensic report, $165,140. That's when I found the second smoking gun, and it's the one that made this stop feeling like a family dispute and start feeling like exactly what it was. The CD withdrawal, grabbing $20,000 the moment we asked her to leave, 3 full weeks before we'd filed anything, before she had any way of knowing we'd hired a forensic accountant, wasn't panic. It was a woman who understood precisely how much trouble she was in, moving fast to convert what she still had access to into cash before that access closed. One piece of evidence came from a place we never anticipated. Preeti, while tracing Diane's own accounts, noticed regular transfers to a woman named Sandra, Diane's longtime friend, and, it turned out, the notary who'd handled our original in-person power of attorney signing at the bank. Carla had her deposed.
Sandra's testimony wasn't about wrongdoing on her part. The original in-person POA notarization had been legitimate, done correctly, with both Mark and me physically present. But under questioning, Diane mentioned that Diane had called her several months into my bed rest, asking detailed questions about how strict the rules really are for remote online notarization versus in person, and specifically whether a notary could rely on a photo for identity verification if the signer claimed to be unable to get to a video call easily. Sandra told her, accurately, that reputable notaries wouldn't do that, which is likely why Diane ultimately used a different, less careful notary service for the fraudulent HELOC closing, rather than going back to someone who actually knew our family. That conversation, logged in Sandra's own phone records and confirmed under oath, became powerful circumstantial evidence at trial. It showed Diane researching the exact loophole she'd go on to exploit weeks before she exploited it, which directly undercut any claim that the forged e-notarization had been some kind of accident or misunderstanding by an overwhelmed relative just trying to help. Preeti also cross-referenced Diane's calendar, subpoenaed from her own phone backup, against the timeline of major withdrawals. 9 of the 11 largest transactions occurred within 48 hours of a scheduled OB appointment or hospital visit for me, the exact windows when Diane knew, with certainty, that I would be the most distracted, the most frightened, and the least likely to be checking a banking app. Like the holiday-timed withdrawals in cases I've covered before, this pattern told its own story, someone managing the theft around the calendar of my worst days, not coincidentally, but deliberately. Here's the part that still makes me tense up when I think about it. About 5 weeks into Carla's involvement, once Diane's attorney realized the forensic report was going to be devastating in front of a jury, Diane attempted to sell a rental property she owned, a small duplex that was, by that point, one of the few significant assets she still had that a judgment could actually attach to. She listed it quietly, without telling anyone in the family, with a closing date set less than 3 weeks out. Carla caught it through a routine title search her office ran once litigation looked likely, and moved immediately to file a pre-judgment writ of attachment against the property, a legal mechanism that allows a plaintiff to freeze a specific asset before trial when there's strong evidence the defendant is trying to move or liquidate it in anticipation of lose it.
Granted, it based on Preeti's forensic report and the CD withdrawal timeline, which together painted a clear picture of someone actively working to put assets out of reach. If that sale had closed even a week earlier, before Carla's office caught it, a huge portion of what we eventually recovered would have vanished into an account we might never have been able to trace, and a sale to a buyer with no knowledge of any of this, and full legal claim to a property they'd purchased in good faith. We came within about 10 days of that happening. Unlike some financial exploitation cases where the district attorney's office waves it off as a private family matter, Carla made sure our local DA's office understood exactly what we were bringing them: a forged e-notarized signature on a HELOC closing disclosure, a shell LLC created specifically to bill an HSA for services never rendered, and a dependent adult financial exploitation statute that applied directly to my medically documented bed rest. This wasn't a blurry family disagreement. It was identity theft, forgery, and financial exploitation, with a forensic accountant's report and a business registry filing to back every claim. The district attorney's office took it seriously. In March, roughly 5 months after Ren's birth, Diane was formally charged with identity theft, forgery, and financial exploitation of a dependent adult, a felony in our state given the dollar amount involved, which crossed well past the threshold that separates misdemeanor from felony theft charges. We also, separately, pursued the civil case Carla had already built, seeking full restitution plus damages, since a criminal conviction alone doesn't automatically put money back in your account. The civil judgment is what actually does that. The evidence, laid out for a jury, was about as clean as financial fraud cases get. The e-notarization log from the credit union showed a 90-second video call and a static Facebook photo used as identity verification, not a live signature. The LLC formation date 2 months before my bed rest even began directly contradicted Diane's own claim, made under oath in a pre-trial deposition, that Willow & Sage was an existing business she'd simply recommended. Preeti's forensic accounting tied every single dollar to a specific, dated, traceable transaction, and the CD withdrawal, 3 days after being asked to move out, gave the jury a clear, human, understandable moment of guilt in action. Nobody grabs $20,000 in 3 days unless they know exactly what's coming. Diane's defense attorney tried to argue that the power of attorney gave her broad legitimate authority and that this was fundamentally a family dispute over how that authority was used, not a crime. The prosecutor's response, which I still think about, was simple. A power of attorney is a legal tool for acting in someone else's best interest, not a blank check. And nothing about a shell LLC formed months in advance, a forged e-notarization, or a frantic asset grab the moment she was asked to leave looks like anyone acting in my best interest.
In August, roughly 10 months after Ren was born, a jury convicted Diane on all counts: identity theft, forgery, and financial exploitation of a dependent adult. At sentencing, the judge imposed 18 months in state prison, followed by 5 years of probation, and ordered full restitution as a condition of that probation, meaning the debt doesn't just sit there theoretically. Failing to pay it back puts her probation and her freedom directly at risk. Separately, the civil judgment Carla had pursued was finalized around the same time: $165,140 in principal restitution, plus $19,600 in pre-judgment interest, plus $31,000 in attorney's fees and litigation costs that the court required Diane to cover on top of the theft itself. Total judgment: $215,740. The frozen duplex, the one Carla's office caught being quietly sold, was sold instead through a court-supervised process, with the proceeds applied directly against the judgment, covering close to half of it in one transaction. The rest was structured as a wage garnishment against any future income and a lien against her remaining assets, continuing to accrue interest until paid in full. The HELOC itself, once the credit union's own fraud investigation confirmed the e-notarization irregularities, was voided entirely, meaning Mark and I were not held responsible for the debt on our own home, since it had never legitimately been ours to begin with. Here's the part of this story that reframed everything for me, the way I imagine it will for you too. I'd assumed for a long time that Diane's motive was something close to entitlement, a mother-in-law who felt she deserved access to her son's household because of everything she'd done for the family, similar to stories I'd heard from friends about controlling in-laws. What Preeti's forensic accounting eventually revealed, once it traced where Diane's own money had gone, was different and honestly sadder in a way that doesn't excuse any of it. Diane had been quietly propping up a boyfriend of 2 years, a man named Gerald, who none of the family had ever fully met, and who, it turned out, had his own significant debts from a failed used car dealership. Nearly $90,000 of what she took, more than half the total, had gone directly into Gerald's accounts or into paying off debts in his name over the course of my pregnancy. The Postpartum Doula shell company, the HELOC, the CD withdrawal, all of it, in the end, wasn't about the baby or even really about controlling our household. It was funding a relationship she'd kept almost entirely hidden from her own son, using her position of trust during the most vulnerable 5 months of my life as the fastest, quietest source of cash she had access to. Mark found that out in the same courtroom I did. His mother had put a man he'd never properly met ahead of $46,000 drawn against his childhood home's equity, and had done it while he was working overtime to support a wife on bed rest and a daughter in the NICU.
Financially, we're most of the way back. The store card and voided HELOC came off our credit reports within a few months once the fraud determinations were finalized. The civil judgment is actively being collected against, and every payment that comes in goes straight back into the house fund it was stolen from. We've since set up our own emergency fund and house savings in an account that requires both our signatures for any transfer over $500, a small, deliberate friction we never used to think we needed. We also, on Carla's recommendation, revoked and completely redid our estate planning. A new power of attorney naming Mark's cousin, someone with zero financial access to either of us day to day, specifically so that if we ever need one again, the person holding it has no existing entanglement with our accounts to exploit. Emotionally, that part is still ongoing. Mark hasn't spoken to his mother since the sentencing. I think about those 5 months of bed rest sometimes and feel a strange, layered grief. Grief for how frightened I was for Ren, and a separate, colder grief for realizing that the person I trusted to hold my life together while I couldn't was quietly taking it apart at the same time. We told Ren's story to our closest circle carefully and slowly, on our own timeline, not because we're ashamed of it, but because we wanted the people around her to understand why certain names don't come up at birthdays. Extended family reacted about how you'd expect. Some disbelief at first, a few "surely there's more to it" comments before the trial transcripts made the picture impossible to argue with, and eventually a kind of quiet consensus that formed once the conviction came down. Diane's sister, Ren's great-aunt, sent us a long letter after the sentencing that I still have, apologizing for not asking more questions herself during those 5 months, and admitting she'd noticed Diane seemed unusually cash-strapped in the years before my pregnancy and had never thought to mention it. I don't think anyone in the family could have predicted the specific shape this took, but almost everyone, in hindsight, had a small piece of the picture they hadn't shared. We also changed how we think about asking for help entirely. When my sister flew in for 2 weeks after we brought Ren home the second time, after that first rocky stretch, we set up something almost comically formal for a family, a shared spreadsheet visible to both Mark and me at all times, logging every purchase she made on our behalf, reimbursed weekly, no standing account access, no authorized user status, nothing that couldn't be undone in 5 minutes if it ever needed to be. It felt strange at first, almost insulting to ask of someone we trusted completely, but it's the kind of friction we've decided is simply worth having now, for anyone, no matter how close, no matter how well-intentioned they seem walking in the door. I hear from a lot of people after stories like this, especially anyone who's pregnant, postpartum, recovering from surgery, or otherwise temporarily dependent on someone else. So before you go, here's the actual pattern, stripped down to what mattered. 1. Anyone who wants sole control of your explanation of benefits and billing correspondence. It's fine to have help. It's not fine to never see the actual document yourself. Ask for the EOB.
The invoice, the statement, not a verbal summary every time, even if it takes an extra 5 minutes you don't feel like you have. 2. A power of attorney set up faster than feels necessary by the person who benefits from it. A POA is a legitimate, often genuinely useful tool, but the person who suggests it, drafts the urgency around it, and stands to gain from it should not be the only person you consult before signing it. Get independent advice, even just a quick call to an attorney, before granting anyone that kind of authority. 3. Being cut off from your own financial conversations framed as protection. Don't worry about it, I'm handling it. And let's not stress your husband with this, are not inherently sinister on their own, but repeated consistently over months, they function to isolate you from the two people best positioned to catch a problem, your spouse and yourself. 4. A business or service you've never independently verified being paid through your accounts. If someone recommends a vendor, a caregiver, a service provider, verify it exists independently. Look up the business registration, ask for a direct contact. A legitimate provider will never be difficult to independently confirm. 5. Someone controlling who has access to you. Restricting visitors, restricting phone calls, restricting who you talk to, even when it's framed entirely around your rest and your health, concentrates power in exactly the way that makes financial exploitation easier to hide. Trust your gut if the restrictions feel more convenient for them than protective for you. 6. A caretaker who resists any kind of second set of eyes. Anytime I gently suggested during those 5 months that maybe Mark should sit in on a call with the insurance company or the bank, Diane had a reason it wasn't necessary. He was busy. It was too small a thing to bother him with. She'd already handled it. A person acting in good faith on your behalf generally welcomes transparency with the other people who love you. A person exploiting that access tends to prefer an audience of exactly one. If you're in a vulnerable stretch right now, a high-risk pregnancy, a surgery recovery, a serious illness, and someone has stepped into a caretaking role that includes your money, here's what to actually do. First, insist on seeing every document yourself, even if someone else is handling the follow-up. A photo of a statement takes 30 seconds. Second, if you sign a power of attorney, make sure it's specific rather than unlimited where possible, and know that you can revoke it in writing at any time while you're mentally competent to do so. It's not a one-way door. Third, set up transaction alerts on every account you have for any amount, sent straight to your own phone, not filtered through anyone else's summary.
It was week 25, a Sunday afternoon. I was propped up on pillows doing the thing you do endlessly on bed rest, which is essentially waiting. Waiting for the next appointment, the next kick, the next milestone that means the baby's a little safer. Mark had gone to pick up dinner. Diane came in with a folder of paperwork and sat on the edge of the bed, the way she often did when she wanted to talk through something, before Mark gets stressed about it. She walked me through a stack of insurance denials, a pre-authorization for a specialist visit that had been rejected, a billing code dispute, the kind of dense administrative language that on a good day I could parse just fine, but on bed rest, drowning in fatigue and fear, felt like reading a foreign language. "I've got it," she kept saying, tapping each page. "I'll call them Monday. You just rest." I remember feeling an almost physical wave of relief every time she said that. Someone competent had this. I could just lie here and think about the baby. At one point in that same conversation, she mentioned, gently, that she thought it might also make sense for her to be added to our HSA card, since I'm the one driving to the pharmacy anyway, and that she'd already looked into it and it was a simple form, 5 minutes. I said sure. I didn't ask a single follow-up question. 2 weeks later, in that same guest room ritual, came the conversation about the power of attorney I mentioned earlier, presented with the same calm, competent, faintly urgent tone, the same folder, the same "I've already looked into this" framing, that made every step feel like it had already been vetted by someone smarter and more capable than the version of me lying in that bed. Every single expansion of her access came wrapped in the same 3 ingredients: genuine-sounding concern for my health, a claim that she'd already done the legwork, and a subtle implication that questioning it would just create more stress for everyone at the exact moment I had the least capacity in my adult life to push back on anything. I didn't fight it because there was nothing on the surface to fight. Every individual request was reasonable. It was only the accumulation: HSA card, mail access, insurance portal login, power of attorney, authorized user status on checking, all inside about 8 weeks that, looked at as a whole, should have stopped me cold. Looked at one folder at a time on a Sunday afternoon, exhausted and scared for my daughter, it never did. By week 28, Diane had, functionally, complete operational control over our household finances. She had the HSA debit card for medical expenses. She had access to our joint checking account as an authorized user, a request she'd made for convenience, so I'm not constantly asking you to Venmo me for groceries. She had the notarized power of attorney, and she had 5 months of a genuinely exhausted, genuinely frightened pregnant woman who had every reason in the world to hand over the reins and not one spare ounce of energy to double-check how they were being used. We would later determine, through bank records, that the very first unauthorized transaction, a $1,200 transfer out of our savings account into an account we didn't recognize,